Linda, you ready to go? You need a break? Okay. Anyone need a break? It's going to take me about 20 minutes. All right? If you do, during the course of my instructions, we'll stop and take a break. Sure, can you pass these written instructions out, please? Folks, I'm fighting a cold, so I apologize for my voice, but I'm going to read these instructions to you. I spent some time at length writing them out for you. The law is precise, and I have to be precise, and so I can't just sit here and chat with you about it. I have to tell you in some specific terms exactly what your duties are and what the law requires. You'll carry these back to the jury room with you, and if you just listen, that's fine. If you want to read along, that's fine too. The last page that you have, I hope, is the jury verdict sheet. So you should have 8 pages along with the jury verdict sheet. And you see you have a number of options there, and we're going to talk about those options as we go along. Members of the jury, all the evidence has been presented. It's now your duty to decide from this evidence what the true facts are. You must then apply the law, which I'm about to give to you, to those true facts as you find them to be. It's absolutely necessary that you understand and apply the law as I give it to you, not as you think it is or as you might like it to be. This is important because justice requires that everyone tried for the same alleged crime be treated the same way and have the same law applied to him or to her. The defendant, Amanda Hayes, is in a plea of not guilty to the charges of first-degree murder and accessory after the fact of first-degree murder. The fact that the defendant has been charged is no evidence of any guilt. Under our system of justice, when a defendant pleads not guilty, the defendant is not required to prove his or her innocence. The defendant is presumed to be innocent. The state must prove to you that the defendant is guilty beyond a reasonable doubt. A reasonable doubt is a doubt based on reason and common sense, arising out of some or all the evidence that has been presented, or lack or insufficiency of the evidence, as the case may be. Proof beyond a reasonable doubt is proof that fully satisfies or entirely convinces you of the defendant's guilt. You're the sole judges of the accuracy and the believability of all witnesses. You must decide for yourselves whether to believe the testimony of any witness. You can believe all or any part of none of a witness's testimony. In deciding whether to believe a witness, you should use the same test of accuracy and truthfulness which you use in your everyday lives. Among other things, these tests may include the opportunity of the witness to see, hear, know, or remember the facts, occurrences about which the witness has testified, the manner and the appearance of the witness, any interest, bias, or prejudice, or partiality that the witness may have, the apparent understanding and fairness of the witness, whether or not the testimony of the witness is reasonable, and whether the testimony is consistent with other believable evidence in the case. You're also the sole judges of the weight to be given in the evidence. If you decide that certain evidence is believable, you must then determine the importance of that evidence in light of all the other believable evidence in the case. There are 2 types of evidence from which you may find the truth as to the facts of a case: direct evidence and circumstantial evidence. Direct evidence is the testimony of one who asserts actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain or group of facts and circumstances indicating the guilt or innocence of a defendant. The law makes no distinction between the weight to be given to either direct or circumstantial evidence, nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. You should weigh all the evidence of the case. After weighing all the evidence, if you're not convinced of the guilt of the defendant beyond a reasonable doubt, you must find the defendant not guilty. You may find that a witness is interested in the outcome of this trial. You may take the witness's interest into account in deciding whether to believe the witness. If you believe the testimony of the witness in whole or in part, you should treat what you believe the same as any other believable evidence. In this case, you've heard evidence from witnesses who have been tendered as experts. An expert witness is permitted to testify in the form of an opinion in a field where the witness purports to have some specialized skill or knowledge. As I've instructed you, you're the sole judges of the credibility of each witness and the weight to be given to the testimony of each witness. In making this determination as to the testimony of an expert witness, you should consider, in addition to the other tests of credibility and weight, the witness's training, qualifications, and experience or lack thereof, the reasons, if any, given for the opinion, whether the opinion is supported by facts that you find from the evidence, whether the opinion is reasonable, and whether it's consistent with other believable evidence in the case. You should consider the opinion of an expert witness, but you're not bound by it. In other words, you're not required to accept an expert witness's opinion to the exclusion of the facts and circumstances disclosed by other testimony. I further instruct you that proof of motive for a crime is permissible and often valuable, but is never essential for conviction. If you are convinced beyond a reasonable doubt that the defendant committed the crime charged, the presence or absence of motive is immaterial. Motive may be shown by facts surrounding the act if they support a reasonable inference of motive. When that's proven, motive becomes a circumstance to be considered by you. The absence of motive is equally a circumstance to be considered on the side of innocence. I also instruct you that if you find from the evidence that the defendant has admitted a fact relating to the crime charged in this case, you should consider all the circumstances under which the admission was made in determining whether it was truthful admission and the weight you will give to it. The defendant has been charged with first-degree murder. Under the law and the evidence in this case, it's your duty to return one of the following verdicts: guilty of first-degree murder, or guilty of second-degree murder, or not guilty. First-degree murder is the unlawful intentional killing of a human being with malice and with premeditation and deliberation. Second-degree murder is the unlawful killing of a human being with malice but without premeditation and deliberation. As to this charge, the state relies upon the legal theory of acting in concert, which is recognized and accepted as part of the law of North Carolina. Under that law, for a person to be guilty of a crime, it is not necessary that she herself personally do all the acts necessary to constitute that crime. If two persons act together with a common purpose to commit the crime of first-degree murder, and each is present at the time that first-degree murder is committed, then each of them is held responsible for the acts committed by the other done in the commission of that crime. The state contends, and the defendant denies, that the defendant acted in concert with Grant Hayes in the killing of Laura Ackerson. For you to find the defendant guilty of first-degree murder, the state must prove 5 things beyond a reasonable doubt. First, the state must prove that the defendant, acting in concert with Grant Hayes, intentionally and with malice, killed Laura Ackerson. Malice means not only hatred, ill will, or spite, as is ordinarily understood, but it also means that condition of mind which prompts a person to take the life of another intentionally, or to intentionally inflict serious injury upon another that proximately results in another person's death without just cause, excuse, or justification, or to wantonly act in such a manner as to manifest depravity of mind, a heart devoid of a sense of social duty, and a callous disregard for human life. Second, the state must prove that the defendant's act was the proximate cause of the victim's death. The proximate cause is a real cause, a cause without which the victim's death would not have occurred. Third, the state must prove beyond a reasonable doubt that the defendant intended to kill Laura Ackerson. Intent is a mental attitude, seldom provable by direct evidence. It must ordinarily be proved by circumstances from which it may be inferred. An intent to kill may be inferred from the nature of the defendant's act, the manner in which the assault was made, and the conduct of the parties, and any other relevant circumstances. Fourth, the state must prove that the defendant acted with premeditation. That is, that the defendant formed the intent to kill the victim over some period of time, however short, before the defendant acted. And fifth, the state must prove that the defendant acted with deliberation, which means that the defendant acted while the defendant was in a cool state of mind. This does not mean that there had to be a total absence of passion or emotion. If the intent to kill was formed with a fixed purpose, not under the influence of some suddenly aroused violent passion, it is immaterial that the defendant was in a state of passion or excited when the intent was carried into effect. Neither premeditation nor deliberation is usually susceptible of direct proof. They may be proven by proof of circumstances from which they may be inferred, such as the lack of provocation by the victim, the conduct of the defendant before, during, and after the killing, the manner in which or means by which the killing was done, and any ill will between the parties. Second-degree murder differs from first-degree murder in that neither specific intent to kill, premeditation, nor deliberation is a necessary element. For you to find the defendant guilty of second-degree murder, the state must prove beyond a reasonable doubt that the defendant, acting in concert with Grant Hayes, unlawfully, intentionally, and with malice, wounded the victim, thereby approximately causing the victim's death. So I instruct you that if you find from the evidence, beyond a reasonable doubt, that on or about the alleged date of July 13th of 2011, the defendant acting in concert with Grant Hayes with malice, kill the victim, thereby approximately causing the victim's death, and that the defendant intended to kill the victim, and that the defendant acted after premeditation and with deliberation, then it would be your duty to return a verdict of guilty of first-degree murder. However, if you do not so find or have a reasonable doubt as to one or more of these things, you will not return a verdict of guilty of first-degree murder, but will determine whether the defendant is guilty of second-degree murder. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant, acting in concert with Grant Hayes, intentionally and with malice, wounded the victim, thereby approximately causing the victim's death, then it would be your duty to return a verdict of guilty of second-degree murder. However, if you do not so find or have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty to the charge of murder. If you have returned a verdict of not guilty to the charge of murder, you must determine whether or not the defendant is guilty of accessory after the fact to murder committed by another person. If you have returned a verdict of guilty to either first-degree murder or second-degree murder, you will stop and will not address the charge of accessory after the fact. Under the law of this state, a defendant who has been found guilty of a murder cannot also be guilty as an accessory after the fact to that same murder. So let me address now the second count involving accessory after the fact. The defendant has also been charged with being an accessory after the fact to the first-degree murder of Laura Ackerson. By her plea of not guilty, the defendant has denied each and every element of that alleged crime. The defendant, by her testimony, denies that she killed Laura Ackerson and denies that she knew that Laura Ackerson was dead until after the defendant arrived in Texas with Grant Hayes. The defendant contends that any act she committed which may have assisted Grant Hayes by concealing evidence that Laura Ackerson had been murdered or by helping dispose of parts of Laura Ackerson's dismembered body was committed by her only because of coercion and duress by Grant Hayes. By this testimony, the defendant has raised the defense of coercion and duress. In the law of this state, the defense of coercion and duress is permitted to excuse criminal acts as involuntary, but only under circumstances in which a person reasonably believes that they must commit those unlawful acts in order to avoid suffering immediate death or serious bodily injury to themselves or to some other person. The burden of proof that the defendant acted only because of duress and coercion to save herself or another person from immediate death or serious bodily injury is upon the defendant. It need not be proved beyond a reasonable doubt by her, but only to your satisfaction. The defendant would not be guilty of the crime of accessory after the fact of murder if her actions were caused by a reasonable belief that she or another person would suffer immediate death or serious bodily injury if she did not commit the acts which constitute the crime charged. The defendant's assertion of coercion and duress is a denial that she voluntarily committed any crime. The burden remains on the state to prove the defendant's guilt beyond a reasonable doubt. For you to find the defendant guilty as an accessory after the fact of first-degree murder, the state must prove two things beyond a reasonable doubt. First, that first-degree murder of Laura Ackerson, as I have defined that crime to you previously, was committed by some person other than the defendant, specifically by Grant Hayes. And second, that after that crime was committed by Grant Hayes, the defendant, knowing that Grant Hayes had committed first-degree murder of Laura Ackerson, willfully, knowingly, and intentionally assisted Grant Hayes to attempt to escape detection, arrest, and punishment by helping Grant Hayes conceal evidence that Laura Ackerson had been murdered, or by disposing of dismembered parts of Laura Ackerson's body, or both. The defendant has testified that Grant Hayes described to her that the death of Laura Ackerson was accidental. She denies that she knew that Laura Ackerson had been murdered by Grant Hayes. A killing is accidental if it is unintentional, occurs during the course of lawful conduct, and does not involve culpable negligence. A killing cannot be intentional or premeditated or culpably negligent if it was the result of an accident. When the defendant asserts that the alleged victim's death was an accident, or that the defendant reasonably believed it to be an accident, these are assertions denying the existence of those facts which the state must prove beyond a reasonable doubt. The burden is on the state to prove those essential elements and, in so doing, disprove the defendant's assertion of accidental death or lack of knowledge of an intentional killing or an intentional wounding with malice causing death. The state must satisfy you beyond a reasonable doubt that the victim's death was not accidental and that the defendant knew that the death was not accidental before you may return a verdict of guilty of any criminal charge. So I instruct you that if you find from the evidence beyond a reasonable doubt that on or about July 13th of 2011, another person, Grant Hayes, committed the first-degree murder of Laura Ackerson, specifically that Grant Hayes intentionally, with malice, after premeditation, and with deliberation, killed Laura Ackerson by acts of violent trauma to her body that proximately caused Laura Ackerson's death, and that the defendant knew that Grant Hayes had committed the first-degree murder of Laura Ackerson, and that the defendant did thereafter knowingly, willfully, and intentionally assist Grant Hayes in attempting to escape detection, arrest, and punishment by helping Grant Hayes conceal evidence that Laura Ackerson had been murdered, or by helping Grant Hayes dispose of dismembered parts of the body of Laura Ackerson. Then it would be your duty to return a verdict of guilty of accessory after the fact of first-degree murder. However, if you do not so find to have a reasonable doubt as to one or more of these things, you would not find the defendant guilty of that crime. You would also not find the defendant guilty of that crime if the defendant has satisfied you that she reasonably believed that she or another person would suffer immediate death or serious bodily injury if she did not commit the acts which constitute this crime. If you do not find the defendant guilty of accessory after the fact of first-degree murder, you must determine whether or not she's guilty of accessory after the fact of second-degree murder. You will recall my previous definition of second-degree murder. If the state fails to prove beyond a reasonable doubt that Grant Hayes committed first-degree murder of Laura Ackerson, or even if the state has proven that Grant Hayes committed all the elements of that crime beyond a reasonable doubt, but has failed to prove beyond a reasonable doubt that the defendant knew that Grant Hayes had committed first-degree murder of Laura Ackerson, the defendant could be guilty of no crime greater than accessory after the fact of second-degree murder if the state proves that Grant Hayes committed murder by intentionally inflicting violent trauma to the victim with malice, proximately causing the victim's death, and the defendant knew that, the defendant knowing that, did thereafter knowingly, intentionally, and willfully assist Grant Hayes to attempt to escape detection, arrest, and punishment by voluntarily helping him conceal evidence that Laura Ackerson had been murdered, or by helping him dispose of dismembered parts of the body of Laura Ackerson, or both. For you to find the defendant guilty of accessory after the fact of second-degree murder, the state must prove beyond a reasonable doubt that Grant Hayes intentionally and with malice inflicted violent acts of trauma to the body of Laura Ackerson that proximately caused Laura Ackerson's death, and that the defendant knew that Grant Hayes had intentionally inflicted violent acts of trauma to the body of Laura Ackerson with malice, which proximately caused her death, and that the defendant thereafter, with that knowledge, did knowingly, intentionally, and willfully assist Grant Hayes to attempt to escape detection, arrest, and punishment by voluntarily helping him conceal evidence that Laura Ackerson had been murdered, or by helping him dispose of dismembered parts of the body of Laura Ackerson, or both. So finally, I instruct you that if you find from the evidence beyond a reasonable doubt that Grant Hayes intentionally and with malice inflicted violent acts of trauma to the body of Laura Ackerson, thereby proximately causing her death on or about July 13th of 2011, and that the defendant knew that Grant Hayes had intentionally and with malice inflicted violent acts of trauma to the body of Laura Ackerson, thereby proximately causing her death, and that thereafter the defendant, with that knowledge, did knowingly, intentionally, and willingly assist Grant Hayes to attempt to escape detection, arrest, and punishment by helping him conceal evidence that Laura Ackerson had been murdered, or by helping him dispose of dismembered parts of the body of Laura Ackerson, then it would be your duty to return a verdict of guilty of accessory after the fact to second-degree murder. However, if you fail to so find, or have a reasonable doubt as to one or more of these things, then it would be your duty to return a verdict of not guilty of this alleged crime. It would also be your duty to return a verdict of not guilty if the defendant has satisfied you that she reasonably believed that she or another person would suffer immediate death or serious bodily injury if she did not commit the acts which constitute this crime. So finally, members of the jury, you've heard the evidence in the case, you've heard the arguments of the attorneys. If your recollection of the evidence differs from that of the attorneys, you are to rely solely upon your own recollection. Your duty is to remember the evidence, whether it's been called to your attention or not. You should consider all the evidence, the arguments, the contentions, and the positions urged by the attorneys, and any other contention that arises from the evidence. The law, as you would expect, requires the presiding judge to be entirely impartial. You should not infer from anything I have done or said that the evidence is to be believed or disbelieved, that a fact has been proven or not proven, or what your findings ought to be. It's your duty to find the true facts and render a verdict reflecting the truth as you see it. All 12 of you must agree on your verdict. You cannot reach a verdict by majority vote. When you have arrived at a unanimous verdict as to each charge, your foreperson should so indicate that verdict on the verdict sheet. After you reach the jury room, the first order of business will be to select a foreperson. And I'm going to let you retire in just a moment to begin your deliberations. If you look at the verdict sheet on the last page, I think I'll have the original here, and I'll mark it original. You can see that it reads, State versus Amanda Smith Hayes. We, the jury, by unanimous verdict, find the defendant, Amanda Smith Hayes, to be, count one, guilty of first-degree murder, or guilty of second-degree murder, or not guilty of murder. And as I've instructed you, and as the verdict sheet indicates, if you found the defendant guilty of murder, either of first or second degree, stop, don't answer, count two. If you found the defendant not guilty of murder, you must proceed on and answer count two. Count two reads guilty of accessory after the fact of first degree murder, or guilty of accessory after the fact of second degree murder, or not guilty of accessory after the fact of murder. Let me see the lawyers up here, please. You've been here since about 2 o'clock, and so there are just a couple of things that I need to put on the record that the attorneys have asked me to put on the record. It'll take me about 5 minutes to do that. After which time I'll bring you, don't begin discussing the case at all. Keep an open mind. At this point, I'm not sending you out to deliberate. I'm going to have you step back to the jury room just for a moment. I will be submitting the case to you in probably 5 or 10 minutes. If there's any of the 12 original jurors that something's come up over the last 2 or 3 weeks that you feel like is going to prevent you from carrying out your duties and responsibilities and making this decision, you need to tell me now, because once I release the alternate jurors, I can't bring them back. So you need to ponder that question too, because I don't know how long it's going to take you to make a decision. We'll be in session until you do. So all of you need to be prepared to finish carrying out the duty and responsibility that you agreed to. If you have anything going on in your life that wasn't going on 2 or 3 weeks ago and that you're worried about now, you need to let me know that before I release the alternate jurors. And when you come back in, if the alternate jurors have anything in the jury room, bring it back in with you, because if I release y'all, you won't be going back to the jury room. Okay. Thank you very much. Just leave your notes in your chair though right now. Step back to the jury room just for a minute. Keep an open mind. Don't discuss the case among yourselves at all. jury's absent. Does the state have any objection to the charge as given?
No.
And I apologize, folks. The pattern jury instruction does include the language that is now in the verdict sheet that I gave them, and I showed you all at the bench. I apologize that I did not. When I noticed that it wasn't in the original verdict sheet that the clerk had prepared, I instructed her to also include in the verdict sheet after the count one, guilty of first-degree murder or guilty of second-degree murder or not guilty, the language, if you have found the defendant guilty of murder, stop and do not consider count two. If you have found the defendant not guilty of murder, you must decide count two. That is the law of the state, and that's how I would charge them. Ms. Godwin, you said that maybe y'all wanted to put something on the record. I'm not sure what it was.
In light of my understanding of the case law on that issue, North Carolina is not an equipped first state. And
Yes, sir.
It's my understanding that North Carolina does not consider itself in terms of alternate counts like we have in this case, where they have to choose between a count. That we're not an equipped first state, and that if the jury were unable to reach a verdict on count one, but were able to reach a verdict on count two, then that verdict would stand. And I would ask the court to consider that in the way that he instructs the jury. The way the verdict form and the instruction reads presently is it leads the jury to believe that they must acquit on the first count before they can consider the second count, and I don't believe that's consistent with prevailing law. I think they have to consider count one, and for whatever reason, if they're unable to come to some agreement there, whether it's guilty or not guilty, if they're unable to reach an agreement, or they consider that, or they have agreed that the defendant is not guilty, then they can go to count two. But it doesn't require a finding of not guilty to reach count two.
As I said the other day, I think the only case that is important on that is one in which the jury actually came back and said they were hopelessly deadlocked with regard to a greater charge, and asked for instruction. And the court indicated that it would be appropriate for the trial judge to allow them to proceed to the lesser charge. And if the jury comes back and tells me that they're hopelessly deadlocked on one of the greater charges, I'll consider any request that you make to allow the jury to move to another charge. But I'm not going to put that in the instruction. Otherwise, the jury could just, after 10 minutes, say, well, we can't agree on first, and then go to second, and then after 10 minutes, they could say, well, we can't agree on second, and we'll go to accessory after and first, and after 10 minutes, they decided we couldn't agree on that, and get all the way down to the bottom of the verdict sheet in no time at all. I don't think that's what the legislature or the laws of the state anticipate. So I note your request, it's denied, but if they tell me they're hopelessly deadlocked on a more serious charge and ask for instruction, I will consider any requests that you make about allowing them to move from that charge to another one. All right? Anything else?
Mr. Chairman, the state gave notice of an aggravating factor. I just want the court to be aware of that and dealing with alternate jurors.
What was the aggravating factor?
It's not in front of me, but it's that the criminal activity occurred in front of the victim's children. It wasn't a statutory aggravating factor. It was under the last category.
Is that an aggravating factor that you contend applies to the homicide charge only? I don't know of any evidence that the that any act of being accessory after occurred in the presence of the children.
Your Honor, I would argue that there is evidence that the accessory after the fact occurred in front of the children. Disposal and dismemberment of that body inside that apartment between July 13th and July 16th.
I don't know that there's any evidence of any of the acts occurred in the presence of any of the children, but I'll just let the alternates go home and be instructed not to discuss the matter and be available to come back for any further proceedings that may be necessary. Is there something else that you wanted me to do with them?
Your Honor, if I may be heard briefly.
Right.
Based upon the argument Ms. Holt made to the jury concerning the defendants having exercised her right not to make a statement to the police officers, I would make a motion for a mistrial. I don't wish to be heard on it, but I believe that she argued that the defendant was in the police car with a Kinston police officer and that she had every opportunity to tell the Kinston police officer whatever she wanted to tell him or her, and that she did not do that.
No, that motion is denied. It's clear to me that her argument was that if the defendant was acting under duress, as she by her defense of the arrest claim, that she had every opportunity at an early time to let the officers know of her concern for her own safety and the safety of her children, and she failed to do that. I don't think that that in any way required that she admit or acknowledge that she committed any crime in order to let officers know that she was in fear of her life and in fear of the life of her children. So.
And Your Honor, I would like to, for the record, that dealt with the July the 22nd involving the search warrant. It was not at the time of arrest. That's when the arrest was 2 days later. So this was.
I understand that.
Okay. I understand that.
Okay. Anything else? All right. Well, let's see how many jurors we've got that are still prepared to go forward. Sheriff, bring the jury in, please. We're back in session. All the jurors are again present. Ladies and gentlemen, I'm about to submit the case to you. Can I look? Are there any of the original 12 jurors have some emergency come up or for any reason unable to continue as a juror in the case? I feel like I should be made aware of some potential emergency that might prevent you from carrying out the rest of your duties here? If so, let me know, please. That's why we have alternate jurors. Show on the record that no jurors so indicated, and I accept the fact that all jurors are now prepared to go forward and carry out their responsibility. Folks, I'm going to write original verdict sheet on the one that I have here. This is the verdict sheet that you will use in having your foreperson record your verdict and presenting the verdict to the court. Your first order of business when you retire will be to select a foreperson to lead you in your deliberations, and then discuss this as reasonable men and women, determine what you find the true facts to be, and then render a verdict that you find reflects the truth as you see it. When all 12 of you unanimously agree, follow the instructions that I've given you, and you've recorded that verdict on the verdict sheet, let us know. We'll take your verdict. We'll go till maybe 5:30 or so today. We'll go to when y'all want to stop, okay? I mean, you may want to stop at 5 o'clock. You may want to stop a little while later when all of you decide when you're ready to quit. We'll quit if you haven't reached a verdict by then. We can't stay real late, but we'll stay a while. I'll kind of let y'all decide what your schedule will be. Some of you have to get home at about 5. You need to honor that commitment with the other jurors, and we'll stop about then. So if I don't hear from you, I'll just make some inquiry by probably about 5:30 or so. You can take your notes with you. Take all the documents that you already have with you that have been passed out. I'll let you retire and begin your deliberations after you've selected a full person. Thank you very much. You may retire. Yes, sir.
Can we take some time to run downstairs and possibly get some soft drinks and stuff to drink?
Okay. Yeah, sure. I tell you what. I'm going to let you. If you need to make a phone call, anything like that, I'm going to let you retire. But I'm going to instruct you not to begin deliberating until all 12 jurors are in the jury room. Let the bailiff know when all 12 of you are there, and then you will begin your deliberations. Select your full person, then begin your deliberations in the case, following the instructions that I've given you. Thank you very much. You can step back to the jury room. When all 12 of you are present, you can begin deliberating. Thank you. The alternate jurors will remain. Alternate jurors remain in the courtroom, please. Thank you. Uh, 12 original jurors have retired. The 3 alternate jurors, Mr. Sh in the courtroom. Let me see y'all up here. sacrifice you've made, and it has been a sacrifice, and we all understand and appreciate that, and I can't describe to you how much I appreciate your careful attention to this case as an alternate juror. It's not unusual to lose jurors during the course of a trial like this. I mean, I've tried cases in which we lost 2 or 3 jurors, so I actually expected that at least one of you would serve, if not all of you would serve. I'm delighted that no one's gotten sick or ill or otherwise disqualified, and we can proceed on. There's a little bit of an issue here because we're talking with the bench, because there's a aspect of the case in which if the defendant is found guilty of any crime, then the jury will also participate in the sentencing hearing. And the question was whether or not to bring you back for that, and I've decided not to do that. The original jury, if they find the defendant guilty of some crime, then they'll be asked to participate in that, and you will not be required any further to participate in this trial. If you want to take all those things you've got with you, you can. If you want to leave them with the clerk, your notes, you can, or with the bailiff, and she'll give them to the clerk, and we'll destroy them. That's entirely up to you. The restrictions that have been imposed on you are now lifted. You can talk to anybody you want to about this case. You can listen to anything on the radio or on TV or go on the internet and actually re-watch the trial, I suspect, if you wanted to. You could actually go on the internet and re-watch the trial if you wanted to. See every commentary you wanted to or anything else. I'm just telling you that all the things that you couldn't do before, you can do now. If you want to talk to your neighbors about it, fine. If you don't, tell them I don't want to talk about it. But we really appreciate the careful attention you've given to the case, the sacrifice that you made, and the understanding you now probably better appreciate that this is democracy in its purest form, and we have to make these kinds of decisions. I don't make them. You know, we got 12 citizens that make these kind of decisions, and that's why you were here, and that's why you're asked to be here, and we greatly appreciate your willingness to do this. The clerk will send you a check in a week or two, and the amount of the check is an insult. Obviously, if we paid you for the value of your services, we could not afford to have you here any more than we could afford to have those kids over in Afghanistan or anywhere that do their part in the democracy that we very much cherish and endure. We also are going to make some effort, Mr. Scheck, to compensate you for the inconvenience that you suffered by not having to be able to get home for a couple of days in that snowstorm. But I'll be addressing that issue later after the trial is over with. We thank you very much, and we'll excuse you at this time. Thank you. Hope you all have a good day. Folks, I'm going to wait till the bailiffs told me that we have all the jurors in the jury room, and then we'll send the verdict sheet in, and they will begin the deliberations. We'll go to about probably 5:30 or so tonight, unless they tell me they want to go a little longer, and then we'll adjourn and start in the morning at 9:30.
One thing on the record, Your Honor.
Sure.
The jurors were given handouts of State's Exhibit 228, 229, and 230. I believe those were collected the next day, so the jurors can go back to the jury room with any of those exhibits. And I think they were also handed some handouts. I think there was one other handout by the state, one other handout by the defense, and I just wanted the record to reflect that those have all been taken back up by the deputies.
All right. Got them all? Just check and see if they're all in. Okay. Well, I take it, based upon what all of you said, that if the jury asks for any item of evidence, that you will gladly consent to them having it in the jury room. So we'll see if they want to see anything, and we'll see whether or not, after you see what they want to see, whether or not you will continue to gladly consent to it going back in the jury room. verdict sheet and in an envelope to the jury, and all jurors. So she reports that all jurors are back in the jury room. We'll be at ease waiting for the jury verdict. Thank you.